Texas and the American federal system. The federal structure is a division of powers between national and state governments. Powers distributed between the national governments and the states. So in Texas, we have two governments that we are citizens of. We are citizens of Texas, and Texas can make laws respecting us, and we are citizens of the United States, and the United States can make laws concerning us. And the powers that Texas and the United States governments have over us sometimes overlap and sometimes are distinct. One important part of the Constitution concerning the idea of federalism is the Supremacy Clause. This is in Article 6, and it says, "The Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding." So the Constitution, federal laws, and treaties are supreme over state and local constitutions, laws, etc. If there is a conflict between the two, the Constitution is the higher law and it must be upheld. Another important part of the Constitution with regards to federalism is the 10th Amendment. The 10th Amendment says the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. So this just reiterates, or this just emphasizes that the Constitution creates a federal government of limited powers, not unlimited powers. So the government can only do those things which the Constitution grants it the authority to do. Any other things are left for the states to have power over. Louis Brandeis was a Supreme Court justice who in 1932 described one of the benefits or advantages of our system of federalism. He said, "It is one of the happy incidents of the federal system that a single courageous state may, if its citizens choose, serve as a laboratory and try novel social and economic experiments without risk to the rest of the country." So Texas and California and North Dakota may have different approaches to taxation or social policies. If they're allowed to each do their own thing, then they can serve as laboratories. We can study what happens with tax policies in California versus Texas and see which one is best, or social policies in North Carolina versus Texas. We can see which one is best. This chart shows what the government powers are under U.S. federalism. So some powers are reserved for the federal or national government, some are reserved for the state government, and some are concurrent or shared. So on the far left, you see the powers that are only for the national government: the power to regulate foreign and interstate commerce, coin money, tax imports and exports, establish and regulate the postal system, conduct foreign relations and make treaties, create and maintain armed forces, declare war, propose amendments to the U.S. Constitution, and make laws which shall be necessary and proper for carrying out enumerated powers. On the right, the state governments are supposed to be left with the power over these issues: the power to regulate interstate commerce, establish and maintain schools, establish local governments, issue licenses, permits, and certificates, protect public health, safety, and morals. This one, the health, safety, and morals, is sometimes called the police powers of states. That means they have the authority to regulate concerning these issues. The power to maintain a state militia or National Guard and ratify amendments to the U.S. Constitution. Those are also state powers. Now, both state and national governments have the power to levy taxes, borrow money, administer courts. So there are state courts and federal courts, the power to make and enforce laws, build roads and other transportation systems, take private land for public use with just compensation. That's the power of eminent domain. And they both have the authority to charter banks and corporations. Now, one of the ways in which the Constitution limits the powers of states is through the Bill of Rights. This initially wasn't so. When the Bill of Rights was adopted in the 1790s, it was originally applied only to the national government. So the First Amendment, freedom of speech, freedom of religion, freedom of the press, was meant to restrain Congress, not the states. The states had their own bills of rights and their own protections for those things. But gradually, after the Civil War and all the way up to recent days, the rights in the Bill of Rights have been one by one applied to the states with only a few exceptions. So for example, in 1869, in a case called the Justices versus Murray, the Supreme Court said that the Seventh Amendment guaranteed freedom from re-examination of facts at trial, not just in federal courts, but in state courts also. 1925's Gitlau versus New York is a very important one. This established that the First Amendment protected the right to free speech from state governments as well as from the federal government. And you'll go on down through the list. There are many important cases there. McDonald versus Chicago from 2010 was an important one. For many years, there had been debate about whether or not the Second Amendment was a right for individuals or states, whether it applied to the states at all. And in that case, the Supreme Court said that the Second Amendment protects the right to bear arms, the right to own handguns from state and local governments, as well as the federal government. We call this incorporation. So what we say is that the fundamental freedoms in the Bill of Rights have been incorporated against or to the states. Now, two other amendments, the 14th and 15th Amendments, also limit state power in very important ways. These amendments were passed after the Civil War, and their primary intention was to protect the rights of former slaves. But they applied to everybody, not just former slaves. So Amendment 14 said all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. I want to point out three things about Amendment 14. First, it guaranteed the citizenship of former slaves. So states like Texas or Mississippi could not deny that former slaves, freed slaves, were citizens of those states as well as the United States. It also protected the right to due process of law. So a state cannot deprive any person of life, liberty, or property without a trial or a hearing, some fair procedural mechanism for determining whether or not they're actually guilty of a crime and deserve punishment. Last, very important part of this amendment, it says no state can deny to any person within its jurisdiction the equal protection of the laws. So the laws cannot discriminate based on race, I guess, or other factors. Amendment 15 said the right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. Notice it doesn't mention sex, it doesn't mention age. So at this time, you could still deny women the right to vote. You could still deny children the right to vote, and you still can. But you could not deny people the right to vote because of their color or because they used to be held in bondage. The Civil Rights Act of 1964 is a law that restricts state power in very important ways, and it was passed in part to implement the promises of the 14th Amendment, which had kind of gone unfulfilled for almost 100 years. So I want to call your attention to one part of this power. It says the Attorney General must intervene to protect anyone who is being denied the equal protection of the laws on account of his race, color, religion, or national origin, or who is being denied access to a public facility operated by the state or local government. So, in the past, it was common for black people, for example, to be denied access to public swimming pools or other parks, beaches, lakes, other things operated by states and local governments. And this Civil Rights Act says that it's clearly a violation of equal protection of the laws, and the Attorney General is required to intervene to protect people's rights, to stop that sort of thing from happening. In 1965, the Voting Rights Act was passed, and this is meant to protect the rights to vote that were mentioned in the 15th Amendment. So it protects individuals from any voting qualification or prerequisite to voting that is being used to deny or abridge the right of any citizen of the United States to vote on account of race or color. So, for example, in the Jim Crow era, the era of racial segregation, it was common to make people pass a literacy test in order to register to vote. And the literacy test would be unfair. The one that was given to black voters might be 3 or 4 pages long. It might be very difficult. It might require questions that had nothing to do with literacy whatsoever. And it would say something like, if you fail one question on this test, you cannot register to vote. So this was basically a pretext, a trick, deliberately meant to deny people the right to vote based on their skin color. And the Voting Rights Act of 1965 empowers the federal government to try to stop that sort of thing from happening. Another way that the Constitution limits state power is through the idea of preemption. So if a state or local law is inconsistent with the federal law, the state or local law may be declared unconstitutional, and the federal law must be followed. So that's the doctrine of preemption. In other words, the federal law preempts or supersedes state law. So this applies in instances where the Constitution or a law expressly or implicitly preempts a state law. So, for example, a congressional law may say that it intends to preempt any state laws in this field or in this area. But sometimes the preemption is implied. So the Congressional Act doesn't say it intends to preempt state laws, but it either occupies the whole field, meaning the whole topic, leaving no room for states to legislate to the contrary, or there might be a conflict. Congress might pass an act, and then it turns out that that act conflicts with an act in Texas, and you can't follow both acts simultaneously. In that case, the Texas Act either is an obstacle to the Congressional Act and has to give way, or it's impossible to reconcile the two, the conflict between the two. And in those cases, the state law must give way to the federal law. It is preempted by the federal law. The Constitution limits state powers with regards to one another, and it says, for one thing, in the Privileges and Immunities Clause, that states must extend to other states' citizens the privileges and immunities it provides for its citizens. The Full Faith and Credit Clause is another part of Article 4. It says, full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state. There was a question about this for several years when some states allowed gay marriages and some did not, about whether or not the states which did not allow gay marriages had to recognize the marriages performed in other states. And a federal act from the 1990s actually said that no, they did not, and the federal government did not either. This cartoon you can see is kind of expressing the conflict between that idea of not recognizing gay marriages from other states and the full faith and credit clause, which seems to suggest that they should, that they're required to. The Supreme Court cleared up this question in March of 2016 when it said the full faith and credit clause requires states to honor adoptions, and presumably marriages as well, by same-sex parents who move across state lines. Now, there's an exception to this full faith and credit clause and the privileges and immunities clause. States may charge out-of-state tuition to non-residents. That has been upheld by the Supreme Court as not a violation of Article 4. Congress can influence states by using its power of the purse. In other words, it can promise to give them spending or withhold spending, depending on whether or not they pass legislation to Congress's liking. An example of this, an excellent example of this, is from the 1980s when Congress decided that it wanted to have a uniform drinking age throughout the country. It wanted every state to require that people be at least 21 years old in order to buy or drink alcohol. And it didn't have the power to expressly dictate that to states, but it did offer to or promise to withhold some transportation spending unless they changed their laws and brought them into conformity. And it worked. By the end of the 1980s, all of the states had the same legal drinking age. Texas, for example, raised its drinking age from 18 to 21 in 1986. I want to talk about a few interesting and important Supreme Court cases dealing with the concept of federalism. So Hammer versus Dagenhart is a 1917 case, and it involved a Child Labor Act, the Keating-Owen Child Labor Act, which prohibited the interstate shipment of goods produced by child labor. Reuben Dagenhart was the father of a 14-year-old, and he sued on behalf of his son, arguing that his son should have the freedom to work in a textile mill. The argument was that the argument was that Congress had no authority in the Constitution to legislate in this area, that this was a matter reserved to the states. The textile mill was entirely within one state, and so the father's argument was that the business between his son and the mill, the labor issue between them, was a purely state matter, not a congressional matter, and therefore they had no authority to legislate on it. So the Supreme Court agreed with the father. It invalidated the law. It said production, meaning textile production, was not commerce and thus outside the power of Congress to regulate, and the regulation of production was reserved by the 10th Amendment to the states. A Supreme Court Justice named Day wrote that the powers not expressly delegated to the national government are reserved to the states and to the people. Now, he actually misworded the Constitution. The 10th Amendment doesn't say expressly. It just says the powers not delegated to the national government are reserved. And the framers purposely left out the word expressly because they believed that they could not possibly specify every power that might be needed in the future to run the government. In a case about 20 years later, the court took a different approach. With the National Labor Relations Act of 1935, Congress had determined that labor management issues were directly related to the flow of interstate commerce and thus could be regulated by the national government. The National Labor Relations Board accused the Jones and Laughlin Steel Company of discriminating against union members who were employees or employees who were union members. And the steel company argued that Congress did not have authority to regulate this since it was an intrastate matter, not interstate. And if the court had had the same approach that it did 20 years earlier in the Hammer v. Dagenhart case, they would have agreed with the steel company, but they changed their approach. The court held that the Congressional Act, the National Labor Relations Act, regulated industrial activities which had the potential to affect interstate commerce. So the national government was justified in penalizing corporations engaging in interstate commerce which refused to confer and negotiate with their workers. I mentioned a few slides earlier the issue of the drinking age in states and Congress wanting to force the states to raise the drinking age to 21. Well, South Dakota had a drinking age of 19. If you were 19 years old, you could legally purchase alcohol. And South Dakota sued, arguing that Congress had no authority to threaten to withhold or to punish South Dakota by withholding 5% of its federal transportation funds. The Supreme Court disagreed. The Supreme Court said that this was an acceptable use of Congress's power to tax and spend. And one of the things it noted was that the 5% loss was only a partial loss of transportation funds, not a complete loss. But Congress was entitled to do this, to use this method to try to bring about a change in the drinking laws of the states. Printz versus the United States was an important case from 1997. The opinion was written by Antonin Scalia, pictured here, and it concerned the Brady Handgun Violence Prevention Act, also called the Brady Bill. It required local chief law enforcement officers to perform background checks on prospective handgun purchasers until the Attorney General of the United States established a federal system for the same purpose. Two county sheriffs, Jay Printz and Richard Mack, sued separately to challenge the constitutionality of this law. And the question was, can Congress temporarily require state law enforcement officers to regulate handgun purchases by performing these duties called for in the Brady Bill? The court, in a 5-4 decision, said no. It said state legislatures are not subject to federal direction. It said that Congress may require the federal government to regulate commerce directly, in this case by performing background checks on applicants for handgun ownership, but Congress cannot compel state law enforcement officers to fulfill its federal tasks for it, even temporarily. So the problem was not the background checks. If Congress wanted them done, it could have assigned the task to federal employees, but it could not order state employees to do the job for it. The United States versus Morrison is another interesting and controversial case from 2000. In this case, the woman pictured here alleged that two men raped her while she was in college. She sued them in federal court, arguing that they violated a 1994 act called the Violence Against Women Act. So she sued them for a civil remedy, for damages, for what they had allegedly done. They moved to dismiss the lawsuit on the ground that the civil remedy was unconstitutional because Congress lacked the authority to enact it. In other words, they were saying that Congress, under the Commerce Clause and under the 14th Amendment, did not have the authority to legislate again in this area, that this was a state matter, that it was reserved for the states to punish crimes like this. So, did Congress have the authority to enact the Violence Against Women Act of 1994? The court said no. Another 5-4 opinion, very close, very controversial. The court held that Congress lacked the authority to enact a statute under the Commerce Clause or the 14th Amendment, since the statute did not regulate an activity that substantially affected interstate commerce. So it doesn't mean that this behavior, if it was true, was not a crime, that it wasn't worthy of punishment and legislation, but that it was up to the state where it occurred to punish the crime, to legislate regarding it, rather than the federal government. In National Federation of Independent Business versus Sebelius, you had the question again of whether and to what extent Congress can withhold money from the states in order to coerce it into doing something. So in this case, the law was the Patient Protection and Affordable Care Act, also known as ACA, or more commonly Obamacare. And it had several provisions, many of which were challenged in court. This provision that I want to focus on now regarding federalism was about Medicaid. Medicaid is the federal insurance program, health insurance for the poor. And one part of the ACA expanded Medicaid coverage to new people and offered money to the states to pay for that expanded coverage. But there was an important hook or caveat. If the states declined to expand their Medicaid coverage and declined to accept the new funding for that, the bill said they would lose all of their Medicaid funding. So in effect, to keep the Medicaid funding they already had, they had to agree to accept more funding and spend more money of their own down the road to expand coverage to new people. Several states sued, 26 states sued, and their argument was that Congress exceeded its powers when it pressured states into accepting conditions that Congress could not impose directly by threatening to withhold all federal funding under Medicaid. The conclusion by the Supreme Court was that the states were right. Congress does not have authority under the spending clause to threaten the states with complete loss of funding of Medicaid if the states refuse to comply with the expansion. Now I want to focus on one very recent and very controversial showdown between states and the federal government, raising federalism questions. Questions about whether or not, in this case, states like Texas have the constitutional right to regulate or ban abortions, or whether or not that is prohibited by the Constitution. This concerns the Texas Heartbeat Bill, also Senate Bill 8 or SB 8. It was introduced by Senator Brian Hughes, who you can see to Greg Abbott's right, our left in the picture. It was introduced on March 11, 2021. A version of it was introduced the next day by Representative Shelby Slawson in the Texas House of Representatives. It passed both houses, and Governor Greg Abbott signed it into law on May 19, 2021. The Texas Heartbeat Act allows any person to sue someone who performs or induces an abortion or aids and abets one once cardiac activity in an embryo can be detected via ultrasound, which is usually possible beginning at around 6 weeks of pregnancy. So in effect, it banned abortion after 6 weeks. Although an abortion patient may not be named as a defendant, anyone who provides support for an unlawful abortion can be sued in addition to the physician performing the procedure. That includes staff members at clinics, counselors, lawyers, financiers, and others. The Act incentivizes private enforcement by authorizing statutory damages of at least $10,000, in addition to court costs and attorney's fees if a defendant is proven liable. Plaintiffs are not required to have a personal connection to the patient or abortion provider in order to bring a lawsuit under SB 8. The Act contained exceptions in the case of medical emergency, but not for rape or incest. As you can see in this map, this was one of several attempts to regulate abortion over the last 10 years or so, most of which had been blocked in federal courts. The Texas one was not blocked in federal court. There were attempts to do so, probably because of this enforcement mechanism. It was a unique approach, allowing private citizens to enforce the law rather than state officials. Now, the constitutional background for this is Supreme Court cases, the two most important, Roe versus Wade from 1973 and Planned Parenthood versus Casey from 1992. Roe versus Wade was the Supreme Court case that ruled that the Constitution protects a pregnant woman's liberty to choose to have an abortion without excessive government restriction. In a 7-2 case, the court ruled that the Due Process Clause of the 14th Amendment provides a right to privacy that protects a pregnant woman's right to choose whether or not to have an abortion. Planned Parenthood versus Casey, 19 years later, upheld the constitutional right to have an abortion, but it altered the standard for analyzing restrictions on that right, creating a new undue burden standard. It said abortion restrictions would be unconstitutional when they were enacted for the purpose of or effect of placing a substantial obstacle in the path of a woman seeking an abortion of a non-viable fetus. This would be an undue burden on the woman. Now, there were attempts to halt the Texas Fetal Heartbeat Law before it went into effect, but the U.S. Supreme Court refused to do so. It refused to halt SB 8. So it did go into effect on September 1, 2021. And then almost 2 weeks later, September 14, 2021, the U.S. Justice Department asked the federal court in Austin for an injunction blocking the Senate bill from being enforced. The Justice Department said that the ban had gravely and irreparably impaired women's ability to exercise their constitutional right to an abortion across the state. It wrote that a preliminary injunction or a temporary restraining order was necessary to protect the constitutional rights of women in Texas and the sovereign interest of the United States in ensuring that its states respect the terms of the National Compact. The department said it was likely to prevail because SB 8 is unconstitutional and was enacted in violation of the 14th Amendment and the Supremacy Clause. So here you see the showdown over federalism. The federal government was insisting that the Constitution stripped states of the right to regulate in this area, and Texas, of course, disagreed and believed that it did have the right to regulate abortions. Well, that discussion was rendered moot somewhat by a different case, Dobbs versus Jackson, decided in 2022, and the majority opinion was written by Justice Samuel Alito, pictured here. This case was about a Mississippi state law that banned most abortions after the first 15 weeks of pregnancy. In this case, the Supreme Court decided that, or a majority of the court decided, that Roe versus Wade and Planned Parenthood versus Casey were decided wrongly, and it overturned those cases. And this returned to individual states the power to regulate abortion. So according to Dobbs versus Jackson, the 14th Amendment does not protect the right to an abortion. The Constitution is silent on it, and therefore it is a matter, according to the 10th Amendment, reserved for the states to regulate on as they please.